I'm John Hood from Moore Kingston Smith, and I just thought I'd give you a brief overview on how Code of Practice 9, or the contractual disclosure facility offered by HMRC, works. Normally, individuals receive a letter from HMRC stating that they've been offered the opportunity to make a full disclosure of any deliberate tax evasion. Now, a question I'm often asked is what happens if we haven't done anything wrong and we don't believe there is any deliberate behaviour? Well, you have 60 days to decide what you wish to do, and the most sensible thing is to seek advice straight away from a specialist tax advisor to make sure you deal with this properly. Normally what happens is you are offered the opportunity to sign up or alternatively reject their offer. The 60-day time frame is described as your opportunity to work out whether there is anything that needs to be done, and you may wish to fully cooperate with HMRC, and even if there is no tax as far as you're aware that is due, still provide HMRC with any further information which may assist them if they wanted to investigate the matter further. This is a case of where HMRC suspect there's been tax fraud or tax evasion. So there's no dress rehearsal, you have to get this right first time. And the best advice is always to make sure that before you make any response to HMRC that you're entirely comfortable with what you wish to say. The process works in a three-stage process. First of all, HMRC will want to know if there is anything you want to report. They then ask you to provide an outline of any issues which you need to disclose to them. So this is basically information gathering. The second stage is that HMRC will review the information they hold and decide whether or not they accept what they've been told. And then thirdly, the last and hopefully the final stage is resolving the matter with HMRC. Now this may mean that there is some negotiation on the tax liability, or alternatively that you may agree that there is no further tax to pay. But nonetheless, it's a three-stage process. 1, information gathering. 2, assessing whether or not there is a tax liability, and then 3, reaching some kind of conclusion. HMRC do state that if you have anything to disclose, they will give an undertaking that they will not commence any criminal proceedings for the issues disclosed. What does this mean in practice? Well, if you were to tell them about some undeclared bank interest, which was say £200, which had deliberately not been put on your tax return, they would say that that's covered and you would not face any further proceedings. However, if you failed to tell them about some undeclared income, which for example was £10,000, and didn't disclose that at the beginning, you technically would be exposed to a criminal investigation if HMRC felt that was appropriate. So the key to dealing with this matter is to make sure that, as I said earlier, you get it right first time, and whenever you make your response to the 60-day deadline, that you make sure you get it right first time. There is no dress rehearsal. Now, HMRC do have some very strong powers available to them. They can ask for information which goes back up to 20 years. They can also raise assessments of the tax due going back 20 years, and they can also charge penalties, which in cases which involved deliberate behaviour can be as high as 100%. If it's UK, and if it's overseas, that can be 200%. So making sure that you, again, get it right first time, get the right strategy, and deal with this matter in the most efficient and effective way is really important, because ultimately if you cooperate with them, even if there is something you need to tell them about, you can still wrap this up in the most efficient way, and that will ultimately impact on the total amount that's payable. Now, obviously most people have a tax advisor. Why would you need a special advisor? Well, there are specialist advisors for dealing specifically with tax disputes, and we have an in-depth knowledge, a deep understanding of how the tax system works. We understand their information powers, their recovery powers in terms of what they can do to recover unpaid tax, and also the penalty regime. All things that are really key on how to deal with these matters. With Code of Practice 9, you're often asked to prepare a report which sets out the issues that need to be addressed, and that report is key in reassuring HMRC that you've told them about everything. Getting that report right first time is really key, and making sure that you cover all the relevant issues. If there are things where you're uncertain, making sure that those are highlighted, so any assumptions made, you explain why you've made assumptions if you've had to. And if you have adopted a particular methodology to arrive at a particular position or figure, then explaining that as well is really helpful. So getting the right advice at the right time is really key. Now, we're often asked, well, what would happen if you don't respond to HMRC after the 60 days? Well, obviously they do have the opportunity to take this matter on as a criminal investigation. Now, that doesn't normally happen, but again, making sure that you cooperate fully, making sure that you get your facts right first time is really important. So I think the one thing that you should take away from today is get the right advice at the right time to make sure you minimise your exposure. Thanks for listening, and I hope to hear from you soon. Thank you.